sharing with you. Our next speaker is Caspar Bowden, who has a long history as a privacy advocate, and then through most of the 2000s was a senior privacy advisor to Microsoft in Europe. And we're very fortunate to have you, Caspar. I mean, he normally lives in France, but we managed to snap him up as he was speaking on Thursday to the Penn Writers Group in New York, and I met him across the Atlantic and he's here, so great to have you.
Well, thank you very much to Andrew and to Lisa Austin for arranging for me to be here. And I think I maybe have some pertinent things to say about the question before you. And it probably will be helpful if I just give a few words of introduction about what I used to do at Microsoft and why I'm not doing it anymore. My role in Microsoft from about 2005 was to advise a group of people called National Technology Officers. National Technology Officers are people like John Weigelt, CTO in Canada, very senior, heavy-hitting people with deep experience. And in a sense, you could say their mission statement was if Steve Ballmer needed to get a prime minister on the phone in half an hour, those people would be expected to be able to do that. So they're operating at sort of ministerial level. They have to have an excellent understanding of the national IT strategies and projects in a country, to have good understanding of Microsoft's own technology strategy and objectives, and of course have a good understanding of the subject matter. So I have the privilege of advising that group of people in 40 countries, actually wider than Europe, but not the US. So my role was a little bit more global than that, and that meant I had to understand, and I specialized in the privacy, the technology of privacy, privacy by design, as well as international privacy law, and of course the fascinating intersection between the two. So from about 2008 and 2009, I saw within Microsoft the first wave of Live at Edu, the pushing out of these free hosted services, essentially rebadged for the educational institutional context. And I was sort of required to go around sort of evangelizing these, in a sense, making the case to my technology officers and directly to government audiences and educational audiences why this was a safe thing to do. And I began to ask some questions internally inside Microsoft. In fact, the same kinds of questions that you're now beginning to investigate today. And frankly, I couldn't get any straight answers, even within Microsoft. And it reached a point after about a year where I was just not satisfied professionally that I could make with a good conscience the kinds of claims that I was being required to do in my corporate role. So I actually stopped, and I made clear to my managers and to those parts of Microsoft that were marketing this product that I was not going to be involved in those sort of efforts any longer. And then things were a bit worse, because I started focusing on the problems of cloud computing specifically, which is mainly what this talk is today. I've given this talk now about 25 times, in fact, in various forms, since I left Microsoft in 2011. And in a sense, the cloud problem subsumes many of the questions, in particular about email and hosted services that are before you today. So with that introduction, we have to go back in time a bit to understand the beginning of the story, back to the 2000s. And we also have to think particularly what we mean by cloud computing. It's not, as I think this audience now understands, it's not just about a place to store your email. It's not just about the cloud as a remote disk drive. For the strategy of the IT industry, what cloud is really about is a transformation to processing data on-premise in one country or in one organization to being able to sell parallel processing power as a commodity at a distance with the data transmitted over the internet. On the left, you can see a modern data center, thousands of blades and racks. And on the right, I've actually shoved two photos together. There's a room, a picture of a room in fact, a telecommunication switching center, and the number on the door is 641A. Does that mean anything to anybody here? Okay, we have a couple of people who've seen this before. So, what room 641A was all about was, in 2003, a senior technician in AT&T's main San Francisco switching center called Mark Klein found that some men from a national security agency arrived in his office one day, and they said, we're here to build a new facility inside your switching center. These are our passes, these are our badges, these are what we're going to do. And what they did was essentially split one of the main fiber optic cables carrying both domestic and international traffic up the western seaboard of the United States, and they split that to a top-of-the-line deep packet inspection box, or the NARA 6400. The performance of these things is much, much bigger nowadays. And this box was triaging and scanning and analyzing the traffic in some way and forwarding some part of that filtered traffic direct back to the NSA. So Mark Klein was very concerned about this. He understood enough about US law to realize that prima facie this is breaking the constitutional protections and statutory protections in US law. And so he took his story to the New York Times, which then sat on the story for 13 months until, in fact, after the next presidential election and George Bush was elected. And then the Times did publish the story in December 2005, and there was a big, big scandal called the Warrantless Wiretapping scandal, which then raged for a couple of years until essentially this was legalized by an interim act called Protect America in 2007. And that essentially introduced the idea of retroactive immunity, or retrospective immunity, for any possibly illegal conduct that collaborating telecommunication companies might have been engaged in, and sort of started to cement this new paradigm of collect all the data and minimize the impact on American citizens later. It also represented, if you like, a breakdown in the system of particular warrants for particular people in particular circumstances, and introduced the idea of a blanket authorization to do mass surveillance on the data and communications of non-Americans. And instead of the Foreign Intelligence Surveillance Court approving particular warrants in particular circumstances, they now approved procedures which accompanied the blanket warrants. So a point I make is that when we have a paradigm of surveillance of that kind, we're no longer talking about requests for data with the supposition that there will be a particular piece of data, allowing due process, allowing a sort of judicial consideration of whether that particular request is justified in those contexts and those circumstances. It's a state of continuous scanning mass surveillance. The diagram you see here was actually prepared by the American Civil Liberties Union in 2006. And what they're able to do is they looked at the documentation which Mark Klein brought with him, and they were able to extrapolate from the serial numbers on the dockets that this installation had not just occurred in San Francisco, it had occurred in most of the major switching centers around the US, and that these pipelines were being fed back, kind of like the tentacles of an octopus, to the National Security Agency in Fort Meade. And there's a little diagram there, also part of the official documentation for the work that was carried out at the splitter installation. So to understand the significance of this legally, we have to look back even further in time to the definition in American law of foreign intelligence information. And this, in fact, goes all the way back to 1978, the first FISA Act, Foreign Intelligence Surveillance Act, which followed the Watergate scandal and the inquiry by Senator Frank Church into illegal surveillance conducted by American intelligence agencies on Americans. And what that did is it erected a categorical difference between the right to privacy under intelligence law between US citizens and everybody else. The definition contains the sorts of things that you might expect: weapons of mass destruction, espionage, clandestine intelligence activities. But it also contains this section highlighted, which you have to unwind through 2 levels of definition to get what I put on the screen. So this very broad term, foreign intelligence information, which you've been following the Snowden revelations, is usually situated in the context of terrorism, but it can also mean this: information with respect to a foreign-based political organization or foreign territory that relates to the conduct of the foreign affairs of the United States. So you can see that's incredibly broad, and that can be just about anything. If you're a non-government organization, if you're campaigning about global warming, if you don't like the Iraq war, anything of that kind meets that definition. A foreign-based political organization does not have to be a political party. It doesn't have to be a government organization. And then again, you've also got this catch-all term, foreign territory. So whereas there is extensive legal commentary in the jurisprudence since 1978 about most of the other sections of this definition, it's interesting and perhaps significant that there is nothing at all in any legal commentary, in any policy commentary, in any executive guidance to clarify the breadth of application of this particular clause. Nothing at all in the literature in 40 years. So what happened after 2007 with the Protect America Act, that was an interim act, and then just before Obama got confirmed as the Democratic candidate, Obama blessed a deal to bundle through, before the 2008 presidential election, on a bipartisan basis, this bill, the FISA Amendment Act, and the particular section I'm going to talk about, which has confusingly two numbers. In the original bill, it was called 1881A. Now everyone calls it Section 702. It's been consolidated into the FISA law. Obama essentially blessed making this permanent on a bipartisan basis just before the election in 2008. So it's all about, as the previous act, the collection of foreign intelligence information with that very broad definition. And it intentionally only allows, I say only allows the targeting of non-Americans located outside the US. Well, that's 95% of the world's population. It gives a blanket authorization for 1 year. It requires the minimization, that is to say, the inadvertent access to data about Americans primarily after collection, but there are some minimization requirements before collection as well. The provider has to give all of the facilities and information to accomplish this surveillance in secret. If they don't comply, it's contempt of the FIS court. Providers have complete immunity from civil lawsuits in the United States, and all of this has to be done in a manner consistent with the Fourth Amendment. We'll come back to that at the end. So this is the scheme that has been up and running since 2008, and clearly it's been in the news a little bit the past 4 or 5 months. So unpicking what was in this act a little bit further, what really happened is 3 elements were brought together for the first time in one place, which had been there separately in the legal regime. Firstly, as we've mentioned, it only targets 95% of the world's population, that is to say non-US persons outside the US. Then, and this is very peculiar, it introduced this term remote computing services. All previous such statutes had dealt with the interception of communications, a message sent from A to B, which you might protect with encryption. Now, for the first time, it brought within scope of this law cloud computing, because that definition, even though it was written in 1986 and shoehorned in from somewhere else, if you think about it, that definition covers all forms of public cloud computing that we recognize today: infrastructure as a service, platform as a service, and software as a service. But the weird thing is, nobody noticed that introduction, those 3 words, into the law in 2008. You can see what a colossal transformation of the surveillance power that entailed. There was no legal commentary, nothing said in Congress, and nothing in the official legal analysis, not a sausage. And then lastly, we have this element that the definition of foreign intelligence information is not necessarily criminality, not necessarily, I think, what we would recognize as vital interest of the state, national security. It's purely political surveillance. It's spying on ordinary, lawful, democratic activities conducted by citizens in their own countries. So you could say, in a real sense, that this was designed for mass surveillance of any cloud data relating to US foreign policy. And I'd emphasize that this law, therefore, codifies what I call a double discrimination by US nationality. Firstly, as you've seen in the very definition of foreign intelligence information, and secondly, in the targeting of the 702 law itself. And in fact, if we just go back a second here to this definition, if you were a United States citizen or legal resident, where it says relates, that would be necessary. So necessary, a very high, strict legal threshold. If you're not an American, relates about the weakest legal threshold you can imagine. That's why it's a discrimination by nationality built in to the very definition. So inside I won't go into the details of why and how I left Microsoft, but I figured this out inside Microsoft, not because anybody told me. I don't have a security clearance, I'm not an American citizen, and frankly I wasn't senior enough to be told this sort of thing. So I didn't know that Microsoft was Prism's first corporate partner. I didn't know that Prism existed, but I did have suspicions. And having read the law and carefully analysed the situation, I was coming to these conclusions from about 2010, and then I left Microsoft in 2011, and then I had the opportunity to write a report incorporating some of these conclusions for the European Parliament, which was commissioned an inquiry into cloud computing, and then published this report, which came out in November 2012, and sort of disappeared without trace, is often the case with these rather stolid and stodgy parliamentary reports. This one was actually mildly sensational, but nobody noticed. And then we did get a little bit of publicity for it in January 2013. It was quite difficult to get any of the media interested at that stage. The blog reaction from Europe was really horrified. How on earth can this be possible? What is the point of all our privacy laws and data protection machinery if this sort of thing could possibly be going on? And frankly, most people were incredulous. They couldn't actually find any holes in the analysis, but they simply could not believe that something of this kind could possibly be going on. The US reaction was much less, but typically, oh, the rest of the world appears to be a bit upset that America has this sort of hegemonical capability for surveillance. Who's going to stop us? Now, in fact, there is a new report after Snowden. The European Parliament sort of phoned me up and said, "My God, Caspar, you're right. And can you write us a new report further analysing the situation from what we know after Snowden?" So that report has now been published as of September. And if you want to know more about, as it were, the whole picture, and particularly the European dimension of this, do have a look at it. It's quite easy to find on Twitter, but I haven't actually incorporated the link yet. The slides, by the way, I'm happy to make available afterwards. So then, of course, we had Snowden in June, and I hope people have been following the coverage in The Guardian. I'm not sure if there's any Canadian paper that's actually got access to the material, has been publishing it. But of course, now there's the Der Spiegel and Washington Post and The Guardian who have been publishing pretty punctiliously methodical stories, it seems to me, from the material they've had access to. I have not seen the material. I have only been talking to some of the journalists and seen what you have seen. But, of course, we now know about the Prism Program, which relies on the 702 law, that Admiral Clapper confirmed on the same day that the revelations came out on June 6th. And then we have these upstream programs, which may rely on 702, but also on something called Executive Order 1233, which is essentially the presidential directive which governs what intelligence agencies are allowed to do outside the territory of the US, wholly outside the territory of the US. And then there is the X-key store system, which appears to be a massive federated database capturing the full take. That is to say, every packet of data, not just metadata, every packet of data is being buffered for something like 3 days at more than 150 global sites around the world from various sources. And an analyst is able to basically do a distributed database search through any of this material, which is far larger than the amount of material which is actually relayed back to the NSA itself. And it indexes pretty much everything. It indexes, obviously, email addresses, buddy lists, any form of identifier, account identifiers, and, interestingly, cookies. So the cookie that the like button drops on your machine on a web page, or a cookie that is claimed to be used just for advertising or commercial purposes, that can be used to target you for political surveillance. So any idea that anyone might have had that you can make some clean division between commercial privacy issues and state surveillance privacy issues is really blown out of the water now. Then there's Bull Run, which is this effort to essentially find sort of side attacks on cryptography. We don't think the mathematics of cryptography has been fundamentally broken, but the implementations, and probably particularly proprietary implementations, are now suspect. And we're in this very parlous situation where we have no idea what to trust. And then recently there's been a story about a program that seems to be based in the UK called Muscular, which is allowing the NSA, or GCHQ, and then to the NSA, to intercept the very high bandwidth data links between data centers. So when you put data into the cloud, typically that data is replicated to 2 or 3 data centers instantaneously, continuously, on 3 different continents, typically the Far East, Europe, and North America. And so the fact that the data flows between these data centers were not being encrypted by Google and Yahoo is rather shocking, because that seems to be, frankly, negligent from even a conventional risk model. And then it emerged just last week in the European Parliament, because they're having an inquiry into all of this at the moment, that Microsoft just admitted that they don't appear to be encrypting their data server to server either. That should be rather significant for you here. In the, when I was doing the analysis in Abstracto last year and before that, I knew that there were these so-called minimization and targeting procedures associated with these blanket 702 warrants, but I never expected to see those in my lifetime. I assumed that those would remain extremely classified documents, never to be seen, and they were published quite early on in The Guardian and The Washington Post as part of the Snowden material, about 9, 15 pages each. And you can go through those with a fine-tooth comb, and there is nothing there which protects non-Americans whatsoever. It's solely phrased in terms of the protection and minimization of Americans' data. No comfort whatsoever for any other nationality at all. Nor is there any restriction on the full breadth of the definition of foreign intelligence information, including the political definition which I mentioned. So how did all this happen? How is it that we have thousands of privacy regulators around the world, thousands of policymakers concerned with cloud computing over the past 4 or 5 years, and nobody spotted this? I mean, the law was in plain view. I read it, anybody else could read it, and draw their own conclusions from the pattern of evidence I've given you. And what seems to have happened is really an organized propaganda campaign. Down on the bottom, I put a number of policy materials, outputs of the US government, even, indeed, speeches by the most eminent data protection authority in Europe, Peter Hustings, the European Data Protection Supervisor. None of these materials mentioned Pfizer at all. None of them really even raised a suspicion that there was any risk of foreign intelligence surveillance of cloud computing in any systematic way. There was, for example, an academic legal project analysing in very great detail the existing law on this at Queen Mary University London. Some very eminent legal academics working on that in a project sponsored by Microsoft. One paper has one footnote about 1881A. No other explication at all. And if you look at the structure of argument in all of these papers, it's very similar. It's basically saying the Fourth Amendment gives very good protection to Americans in America, in many cases better than some European countries' due process over their own citizens in Europe, for example. Therefore, don't worry about the cloud. Well, you can see the fallacy, because as we just explained, if you take non-Americans' data outside the US and you put it in range of American jurisdiction, then you literally have no privacy rights at all, or means of redress, or access to the courts, once that data touches where the NSA can get at it. So one has to draw the reluctant conclusion that some privacy regulators seem to have been acquiescing into a sort of don't worry, be happy about the cloud mantra. If you go through 150 opinions of the fabulously obscurely named Working Party 29, which is in fact just the Committee of European Privacy Regulators, 28 European privacy regulators. They have published 150 sort of detailed quasi-legal opinions on every subject under the sun in privacy since 9/11. They've never mentioned the term foreign intelligence. They've never mentioned Pfizer at all, never mentioned PAA, never mentioned Pfizer 702. Patriot was mentioned once in one footnote in 2001. And then doing some research for this talk, I noticed that on the Interior Commissioner's site in Lukin, she made a presentation back a couple of years ago saying privacy in the clouds. Yes, you can have both. Don't waste your time by focusing on the Patriot Act. There are several other US military clouds provided that grants and local authority. Well, that seems a very odd thing to say if you take that at face value. Don't worry about the Patriot Act because there's something worse. And there's no discussion of what that is. there's no mention of Pfizer in any OPC materials until May 2013. And faithfully, I think there's no analysis of this discrimination by nationality and the implications for that under the Canadian Charter, which I believe are quite similar to the implications under the European Convention of Human Rights. I think somebody may be speaking about those aspects later, but we can go into that in Q&A. And so, bluntly, it does seem that some regulators do conceive their real job as enabling and obfuscating this kind of mass surveillance. It's really very hard to draw other conclusions other than downright incompetence. If you look at the political media debate in the US after Snowden and currently, it's slightly changed in the past 3 weeks since we had the bugging of Angela Merkel's phone. But really, until then, there was no discussion in the domestic political sphere in the US of the rights of anybody else than Americans. Ex-NSA Director Hayden, who was in office around 9/11, was giving some interesting interviews saying the Fourth Amendment is not an international treaty, and talking about a home field advantage that America has in essentially an assumed prerogative to scam and exploit not only data transiting, but data stored within US jurisdiction. And the strange thing was, I've been on the privacy conference circuit for many years, and particularly at the International Privacy Commissioners Conference, there would generally be a State Department representative making a very eloquent, soaring speech to praising the Fourth Amendment. And since this was directed at an international audience, you might draw the inference that it was being supposed the Fourth Amendment offered some protection to the rest of the world. Well, it didn't. And in fact, this situation really only crystallized around 2012. I've left out the sort of legal detective story, which goes back to about 1990. But I'm going to tell you a little short clip next, which is actually a debate in the US House of Representatives from July last year, when FISA 702 was coming up for renewal. And again, the axis of concern was only about the rights of Americans. And watching this stuff, quite closely, I thought this following sequence really crystallized the situation rather eloquently. Oh, sorry, go back.
Does the Fourth Amendment apply to foreign targets in foreign lands? I don't think that's the question. No, that's my question. So I promise you it's the right question. That's my question. Does it apply? I don't think it does. When you say you don't think it does, well, I mean, the circumstance of the statute, I don't think it does. Right? We certainly have a big argument that it does. Does the Fourth Amendment, I'm not talking about the statute, does the Fourth Amendment apply to foreign nationals in foreign lands? It does not. Does the Second Amendment apply? I don't know the first law, but I think no. I think it would depend on the circumstance. Women's suffrage, does that apply? No. That's my point. They don't. So we're not talking about surveillance of foreign nationals in foreign lands, right? Because you don't think there's constitutional immunity. That's my second point.
So, the hapless but doughty civil liberties advocate you saw being rather browbeaten there by the representative from Texas was Jamil Jaffer from the American Civil Liberties Union, and they were making a constitutional argument that this, as it were, incidental impact, the spillover effect of 702 onto Americans, was a constitutional problem sufficient to stop 702 in its tracks. But if you've missed the point, and to be rather blunt, the US Congress was having fun at your expense. They were having a good laugh at the idea that you have any privacy rights under this law, any privacy rights. So I think this leaves us with some questions in the concrete outsourcing debate that we have. And I think the first thing I would say is that risk is not the same as uncertainty. I'm an old rocket scientist, hedge fund hand, used to sort of crunch financial numbers for a living to estimate risk. We can't quantify the kinds of uncertainties introduced by this legislation. We don't know the limits of its exploitation. Everything that's happened since Snowden has been an immense shock, even to every specialist in the surveillance studies field. And Therefore, it's too glib to talk about risk, because we have no way of quantifying the privacy damage or the surveillance impact, the hangover, years and years in the future from this data. We don't know how long this data is kept. We know that there are no legal protections on its exploitation whatsoever. So some concrete questions. I did have a look at the risk assessment, which is published for the current project. It seems to me there's a gaping hole in the definition of enterprise customer data. It's not clear that metadata falls within that definition. So all of the traffic analysis, the who is talking to who, the inferences that can be made from that social structure, appears to be outside the scope of that agreement. How long is that data retained? Which flows are exposed? I don't think we know. How do we trust proprietary implementations of encryption anyway, after Bullrun and Muscular? And if data wasn't being encrypted between data centers, what does that imply about the good faith and prudence of the service providers? Particularly if they didn't seem, shall we say, very forward in coming forward about that. But fundamentally, there's a technical point here, an extremely obvious technical point. And in a sense, this crystallizes everything I've said, that when you talk about hosted services, and in particular webmail, encryption is futile, because 702 gives the power to compel the key or the plain text from the service provider, and do that in complete secrecy. So what are vendor assurances worth, given the secrecy provisions in Pfizer and incidentally in Patriot? And what about the students? You know, if you save the faculty, you throw the students under the bus. Well, overall, I would urge you to think about reducing your risks and uncertainties and not entrenching them. Thank you very much.
We're way over time, but this is important stuff, and so let's take questions. Usual suspects. I'll start with Bob, and then we'll work the rest of that throughout.
Could you just clarify your statement about the keys? A U.S. company is compelled to provide the encryption key. What if they don't have the encryption? Is there, in other words, setting aside for the moment the question of whether there is encryption or whether that is possible, if encryption is possible, if the data are protected by encryption, not by the vendor, how can they be compelled to provide?
So I was looking at the risk document, and you can tell me, but there seemed to be some implication that we were talking about end-to-end encryption with PGP. Now, if you do encrypt email end-to-end with PGP, then as far as we know, the cryptography and at least the open source implementations of that are good. However, you lose some functionality. It becomes very difficult to search and index your mail. Moreover, frankly, PGP has caught on nowhere. It just seems too difficult for people to actually use. And so there is a real question then about, even if the thing is set up in theory, actually seeing an institution, even within that institution, use it systematically. We have never seen that. And then also, it's kind of still more risk, because if you're sending your encrypted email to a foreign server, then particularly with what we now know about the subversion of various channels of security by the NSA, well, that's still kind of riskier than locally confining the data, even if that was unencrypted. But fundamentally, you can also be talking about, and it appears to be from what you said earlier, that they're talking about a situation where Microsoft does have the key, and there are many different email architectures for that. So in those circumstances, there's no question that Microsoft can be compelled to decrypt and hand over plain text. And indeed, there are a range of powers where they could be required to hand over SSL keys as well, as we've seen with the LavaBit case. Many different powers, in fact, to do that, and there's almost an embarrassment of riches, if you like, for the government, US government lawyers to choose from to get access to those keys.
So I acknowledge all that there are these various elements to it, but conceptually, if the vendor does not have the key, they can't be compelled to provide.
The very important point about this is you can only process data in a computer in decrypted form. So either you're talking about the cloud as a big disk drive, but if you're actually running Office 365, doing applications, that data must pass through the CPU in decrypted form. Therefore, Microsoft must have the key. So what Microsoft does is they dynamically decrypt it on the fly, put it through their CPUs, and then encrypt it again when it drops back down the disk.
So is it possible for us to build an encryption system because they can't handle anything we send them that's encrypted?
So there is a very exotic form of encryption called homomorphic encryption, which in theory solves this problem. But it's irrelevant because it's millions of times too slow. It'll never be irrelevant to the real world. Yeah.
I never, don't say never.
Okay. But I guess the point is, even if it was like 10% slower, right? The cloud is such a cutthroat business, and we've seen in Ankabukian's remarks how nervous and frankly cowardly regulators are about prohibiting something or mandating something. I don't think there's any privacy regulator anywhere that has mandated an advanced privacy technology, ever, in like 20 years of research. So even if this stuff was 10% more expensive, as opposed to like 10 million times more expensive, nobody would use it on commercial grounds. If they were allowed to, they'd go to the lowest bidder. So there is no way of constructing these kinds of hosted services where the service provider were blind to having the key.
But more importantly,
Yeah, so you mentioned lots of it, but also back in the day, Nationality, right? Both of those examples are where the service provider did not have the key, but the government requirement on the service provider was that they change their system such that when the user types in their passphrase, which decrypts the document, that typing in would be captured and delivered to the government.
So they're basically requiring the service provider to alter the software to hack into the device, hack into the endpoint. And there's precedent for that.
And also, let me clarify, if you send data completely encrypted to the cloud so that any provider in the cloud cannot use it, you really have to start wondering, why are you sending it so far away and not on your local drive or on your campus drive? If they cannot do anything with the data, there's no reason sending it to them. So you're sending it to them because you want them to access the data. So don't then go and say, well, it's all encrypted. It's not.
John, Seamus, John, anybody else?
I granted I'm not the normal user, but using PGP or BGP doesn't strike me as that difficult. It strikes me that we're at the same point as in the 1960s, we were all later saying, just put the damn seatbelt in the car. If there is a large enough institution that implements PGP and mandates that as a default, which is a privacy by design principle, the default, it becomes, then you start to try to say, well, the seatbelts did. But we have here the eternal dichotomy. I generally agree with you, Caspar, as you know, and we have some terrific technical people. But Bob's got a problem. He's got an out-of-date system. He has he's operating in a climate of political austerity, and he's got 30,000 people that are expecting some kind of email service. So my question to you is, what do you recommend then? So you're not a privacy commissioner, you can't pay.
Yes.
What's a concrete recommendation for a solution that meets both budget and stakeholder demands?
It's a good question. I'll tell you what I've recommended for Europe. At the end of my report to the European Parliament, I did make some very concrete recommendations. So the first recommendation was, I don't think you can stop individuals sending your data to US cloud services. I mean, it's not for governments to prohibit individuals from doing what they like. That's not my philosophy. However, they ought to be informed of the risk with a very drastic warning. So, no kidding, I proposed that essentially if any European was going to use an American offer cloud service, they should get a big fat pop-up warning box saying, abandon hope all ye who click here. If you do click here, then your data may be subject to political surveillance by a foreign intelligence agency. Do you agree? And that obviously is intended to have a political effect, because if we did achieve that, and I don't think unfortunately the European Parliament is going to do that, then I guess millions of people around Europe would say, what on earth is going on? And they'd start to contact their MP, and they'd start to contact their privacy commissioner, and maybe there would be more public understanding of these issues. What I've also suggested for the European scenario is that they develop a European geographic cloud area. Now, there's problems, as we know, in Europe, because European countries, guess what, spy on each other. And they are doing so in a way which is almost certainly breaking the European Convention of Human Rights. And we've had a case where GCHQ has hacked into Belgacom, the main Belgian telecommunications provider, in a way that seems unquestionably illegal. And in fact, the Belgian government could sue the UK government in Strasbourg if they had the guts. But there's probably all sorts of realpolitik reasons why they're not going to do that. But the difference is this: if one European country does that to another European country for political purposes, they are breaking the European human rights framework. If the US does this to foreigners' data, that's totally legal in American terms. And we have to bear in mind that, as it were, baseline legal difference, whatever the practicalities are. Nevertheless, for the Canadian situation, it seems to me a no-brainer to cut to the chase that I think you should find a nice open source provider with a stack of free software-based cloud services, and you try and get a good deal and use the innovative free software cloud services, which are pretty good. They may not be as quite as bells and whistles as the latest thing from Google and Microsoft, but you don't have to worry about all this. At least not from the American government. You do have to worry about CSEC, and that's a whole other story.
Alex, do you have a quick, just a very quick one to clarify? I think UK has two mail systems, right? One is called Utor-mail, and the other one, as you mentioned, about the Utor exchange, right? So Utor-mail is the legacy system, but Utor exchange is the industry standard. I think it's called Exchange 2010, right? That in fact most of the top 20 institutions in the US currently use, and it's housed in-house, right? So it is Microsoft product, but it's in-house in UT. That's what's currently being used in UT, right? So that system is not a legacy system.
Jim, I just want to make a minor point about non-U.S. persons, okay, about U.S. citizens. But I can be fairly certain, just like the New York cartoon that showed two dogs sitting in front of the internet, and nobody knows you're a dog on the internet. Nobody knows you're a U.S. person when you're abroad first.
Actually, they do.
Not at first. Not when they first start collecting your stuff. Once they've collected enough, they can work it out. They've already collected.
Well, one of the things we know from the Snowden material is that the NSA does have a database, at least for telephone numbers, and we don't quite know how they compile this, but essentially after they... I haven't talked about the Patriot Act at all today, but there wasn't time. But in that separate discussion, where it also comes into the picture, identifying who's American and who's not, the NSA does have a database of telephone numbers, including mobile numbers, and we don't quite know where they get it from or what legal base they gather it. And I certainly think that we will find that they have a similar database for email and internet type identifiers, and they do kind of minimization effort on that. However, it is absolutely right to say that Americans are in a pretty bad situation too, because when you look at the minimization procedures, if an American sends any data that's encrypted, well, that's allowed to be collected and retained indefinitely. So, in a sense, your primary tool of protecting your privacy is being categorized, in a sense, as prejudicial to your privacy, and you don't know when that's going to be attacked and decrypted in future. And there are many other sort of loopholes and edge cases, which means that Americans' rights have been severely eroded. But I don't think, in a sense, that undercuts the basic point, and the surprising point, that the legal regime I've described operates two completely different systems for Americans and non-Americans. And that is very weird, because as far as I know, only America and New Zealand has a law that works like that. Other people have laws based on universal rights.
Quick question, Jonathan.
Very quick. We apologize for being in the back here. My computer's running out of juice. So, not to pile up with Mr. Cook. But unless I misheard you, Mr. Cook's presentation, he said that there's a view that a lot of the information that's sent in the email system is not highly sensitive, or whether that's true or not. I just wanted your opinion about something that I heard in a talk on Thursday. I was at a talk being given by Alessandro Battisti from Carnegie Mellon University, who's doing some for years, groundbreaking research looking at how big data operates and connections between different types of data. And he was talking about the ability to find highly sensitive personal information from data that is considered non-sensitive. So for example, pictures that people just casually post online and being able to then extract social security numbers by using data sets that have access, great languages. One of the studies that is about to publish, very quickly, one of the studies that's about to publish talks about, actually I don't understand, the question that I have is, do you think that with your experience working with Microsoft and don't know Microsoft, you would have any interest in this sort of capability, the ability to extract highly sensitive information through access to information that's not considered sensitive?
Yes. Okay, I'll say two things about that quickly. One is that I don't necessarily buy the idea that it's prudent to sort of assume that most people's everyday email is not sensitive and, as it were, put the onus on people to take a positive step to protect stuff they consider particularly sensitive. That just doesn't work as a security policy, and I could go on and on about that. That's, frankly, anyone who's recommending that ain't a security person, or a privacy person, even less. Secondly, there's a problem with traffic analysis. What you can infer by the static relationships, the connectivity between people, and particularly the dynamic relationships, how frequently they communicate, is almost like the whole privacy enchilada. And content is far less important once you consider the questions of traffic analysis. Lastly, in terms of Microsoft's role in this, I'm going to be slightly careful what I say, but I mean, there is this division or quasi-think tank Microsoft set up a number of years ago called the Institute for Advanced Technology in Government. And what their job basically is, they're a bunch of ex-spooks and policemen, and they go around selling data mining surveillance solutions to government. So what Microsoft will often do is, with the left hand, sell an e-government solution or an educational private edu solution, and with the right hand, go to the Interior Ministry and say, do you want to buy a whole lot of shiny new database data mining licenses for essentially spying on your own citizens with the stuff we just sold you with the left hand? That's a dirty business, but that is the business.
Great. Question. Well, it's more of a statement that just came from a Twitter interaction that we had. We were just, a prospective student to the iSchool, we asked the question, are you concerned about U.S. surveillance programs like Prism or XKeyscore? And the student said, yes, especially when they involve companies that operate in the U.S. and archive and mine data from clients in other countries. So it's interesting that the perception is already there among many students that this is something to be concerned about.
And I will leave you with that thought, the last point. What about the students? This is about the faculty, but your students' privacy has been sold already.
Yeah, that cheerful note.